It is the time set for probation violation hearing. What's your client's intent?
Your Honor, my client's going to plead guilty to the violation.
All right.
Hasn't been arraigned yet. The summons and arraignment.
All right. So you're charged with probation violation. Did you receive a copy of the charges? Did you receive a copy of the charges?
Yes.
It brings you here today.
Yes.
This is the arraignment. I'm gonna do it right now.
That's right.
All right. Is that a yes?
Yes, Your Honor.
Okay. It's charged you violated probation by count one. The contrary to special condition number 2, Mr. Jones failed to refrain from use of alcohol and tested positive during an ETG at JAMS on 6/1/2022. If you're found to be a violator, you can be sentenced to serve up to 2 years in prison. You are entitled to a contested probation violation hearing. If you can't afford a lawyer, one will be appointed for you and paid for county expense. If you plead guilty, you will be given up your right to a contested hearing. You understand all that?
Yes, Your Honor.
That's you. Blank advice to wait for. Stephanie, would you give this to Mr. Jones and his lawyer, please? You normally have this filled out at the arraignment process. I'll go over with you right here. You're accused of violating one or more probation violation conditions. You have the following basic rights: to receive written notice of the alleged probation violation, to plead guilty or not guilty, or stand mute. If you stand mute, plead not guilty will be entered for you. You have the right to contest the charges with your lawyer's assistance at this hearing and all subsequent hearings. You've got a right to have a lawyer, public expense if you can't afford one. Obviously, you've got Mr. Nolan with you, so that you have to get a court-appointed lawyer for you. At the contested hearing, the evidence against you must be disclosed. You've got the right to be present at the hearing and to present evidence, to examine and cross-examine the witnesses. The court will only consider evidence that relates to this probation violation. The rules of evidence don't apply except those pertaining to privileges. The prosecuting attorney's burden is proving this violation by a preponderance of the evidence. If you plead guilty and your plea is accepted, you'll be given up your right to a hearing. I've already advised you of the maximum possible prison sentence. The court finds that you violated conditions of probation, or if you plead guilty, the court may continue on probation, modify the conditions of probation, extend probation, or revoke probation and sentence you to incarceration. Fines, costs, and other obligations due at time of sentencing. If you can't afford to pay right away, I'll give you a payment plan. You understand the rights I just read? Is this your signature on the form?
Yes, Your Honor.
Okay, we'll accept the probation violation rights document for entry in the court record. You obviously have the money to hire a lawyer because you've got Mr. Nolan, right?
Yes, Your Honor.
All right. We'll refer you to just late. Rather than set a hearing for another day, you ready for a hearing today?
We're ready, Judge.
Okay, very good. Raise your right hand, be sworn. You swear to tell the truth, the whole truth, nothing but the truth, and the matter now pending before this court?
Yes, Your Honor.
All right, you're charged with a probation violation, and did you receive, if you didn't receive written notice, I'll give you a copy of the plea. You got it? Did you get one?
Mr. Jones, you received.
It was sent to the mail, but I think I was at the
He was in the
facility.
recovery. He was at the facility at the time that it was sent out to his home.
All right, you acknowledge receipt of it, though, went to your home?
Yes, sir. Yes, Your Honor.
And I just advised you of the charge order, correct?
Yes, Your Honor.
All right, I'm satisfied you got proper notice. And once again, it's charged you violated probation by that on, as you fail to refrain from the use of alcohol and tested positive during an ETG at the James testing facility on June 1, 2022. If you're found to be a violator, you can be sentenced to serve up to 2 years. You're entitled to contested probation violation hearing in your counsel. You plead guilty, you will be given up the right to a contestant. You understand all that?
Yes, Your Honor.
And you acknowledge that I've thoroughly given you advice or rights when you signed the form.
Yes, Your Honor.
Earlier on this record, you don't need to repeat it, do you?
No, Your Honor.
All right, very good. How do you wish to plead to the fact that you violated probation on June 1, 2022, and that you failed to refrain from the use of alcohol and tested positive during the ETG?
I'm responsible, Your Honor.
Is that guilty or not guilty?
Guilty, Your Honor.
All right. The court does find, so it's true that you did consume alcohol on or about 6/1/2022. That was in violation of your probation, and you violated probation based on the consumption of alcohol and positive test, correct?
Yes, Your Honor.
All right. I do find there's a factual basis for the plea. The court accepts saying, with respect to sentencing, you were convicted of operating while intoxicated, which is a 3-month offense, and reckless driving, which is a 3-month offense by virtue of a plea in this file. This is specifically 26865. This is a file in which the probation violation hearing was brought, or violation was brought. You read the probation violation report, yes? Have you read the probation violation report? It's prepared?
No, Your Honor.
Okay, is your lawyer read it?
I did not receive a copy of it.
Okay, can I have it? Basically, the first page deals with all the conditions of probation. The middle of the second page is a current violation. That's what brings us to court today, which is, so as Mr. Jones failed to refrain from use of alcohol and tested positive during an ETG at JAMS, that's the testing facility on 6/1/2022. Then advises me that the treatment programming that you under Shar House, page 3's got evaluation and plan, and then recommendation.
Yes, Judge, we had a chance to look at it. It is accurate.
Okay, very good. I'll get you a copy of it for your record.
Okay.
Thank you. You want? Prosecutor, do you have anything we should say? Is there anyone here in the Victims' Right Act who should be heard?
Your Honor, I've reviewed the probation violation reports in each case. They are accurate to the best of my ability to confirm that. The guidelines are scored appropriately. There is no one here under the Act to address the court.
All right. Mr. Nolan, have you read this probation violation report? Are there any other additions, corrections, or deletions? Guidelines are 0 to 17 months. Are they correct? Is there anything else you wish to say?
Yes, Judge, the guidelines are correct. All I would say as a way of explanation, not excuse, that he had lost his grandmother earlier that morning. And that caused him to get depressed and make a bad decision. And then he went and got tested on June 1st. Obviously, as soon as we found out of the positive results, he checked himself in the share house for a 29-day program. And he's been there and doing well. He received a letter of what type of treatment he's receiving there. So he took responsibility for it, made a bad decision, took responsibility for it, and tried to get treatment himself so he could come to court today and show that he was proactive in dealing with this issue and the violation. We would just ask the court to adopt a recommendation of probation to allow him to finish this inpatient program. He's due to be released July 6th, and then continue with outpatient programming on a regular basis, however the court sees fit.
All right. Thank you. Mr. Jones, what do you have to say before the court imposes a sentence?
Your Honor, I just apologize. I did make a really poor decision. And, you know, I do appreciate Share House, though. When I got there, we definitely uncovered a few things that, like Ms. Nolan said, it was just an explanation, but not much of an excuse, you know, for the reason why I did take a drink. And so I do appreciate the treatment I've been in. I've been having a great time, learned a lot, not only about the program, but also about myself. So just looking to put this behind me and move forward. Thank you.
Just his recovery coach is here today, which brought him to court. He's still in the program, so he's not out, you know, the streets. He was trying to get treatment.
Alright. Mr. Tagman?
Your Honor, it's people's position that Mr. Jones should not have the benefit of his HYTA any longer based on his actions. This is the fourth violation that he's had during the pendency of this case. First probation violation to this court. He had 3 bond violations in Judge Bain's court, 1 for drinking. This is an alcohol-infused offense. Mr. Jones created a very dangerous situation on the side of the highway where he was challenging the very people that he should be supporting in this case. These were law enforcement officers. He is a lawmaker in this state. He is asking the court to continue to invoke the benefit of HYTA to him, even though he is not living up to his end of the bargain. This was a very favorable plea agreement that was struck between the parties. Mr. Jones has every reason to be motivated to continue to follow the rules and do what he's supposed to do. His very job is to create those rules, and he's here basically thumbing the nose of the court's order. I've heard this court say multiple times that the purpose of a sentencing is not only to deter future criminal behavior on this client, but also to set an example for society and deter others from committing similar situations. Allowing Mr. Jones to stay in YTA does not send that message, Your Honor. I would ask the court to revoke his HYTA status at this time. Allow him to earn it back. If he finishes his probation with no other violations, then reinstate it. I have no problem with that. I'm not asking for jail for Mr. Jones. I'm not asking for anything, but for him to have to live up to the bargain that he struck. Thank you.
Right. YTA, all diesel training Act was put in place to be able to let young people have an opportunity to work through their troubles, and if they show proper trajectory of law-abiding citizenship, that their records would not be marred with a conviction. Since I've sentenced Mr. Jones, been doing what I wanted you to do, done what I've asked you to do. You got to stumble with this matter brings you before the court today, and unfortunately, maybe it took the death of your grandmother to get you to realize that your alcohol problem is greater than what you realized, regardless of other people trying to convince you that there was an alcohol problem. I don't think you were convinced yourself. I think you might have been thinking the words yourself, trying to put you through some hoops without trying to correct an issue that may have been there. And maybe that's a message from your grandmother that you got when you got in the share house. And I'm going to try to give you incentive to stay on that path. You know, you're basically making things harder than what they need to be. All you do is do what you supposed to do in the beginning, is follow the rules, and you wouldn't be here today. But you take an active role to get this done. I think this might work and get you on the path of sobriety. If you're in Livingston County, I'd have you in Livingston County Drug Treatment Court. There's no doubt in my mind that that's what you're a candidate for. But with you being in Wayne County, our rules have that you got to be a resident of our county to be in drug court. It's an intensive treatment. We meet twice a month with this court. We go to 8 AA meetings or self-help meetings a month. We go to counseling 4 times a month. It's pretty intense, but we've got a really good success rate. You're going to have to, and sometimes inpatient treatment ahead of time, and that's what you're doing now. That's what I think is appropriate here. I'm going to send you to 30 days, Livingston County Jail. I'm going to give you credit for day-to-day credit for what you're doing over in Shar House right now. The minute you leave there, you march yourself right over to Livingston County Jail. So I think that I think your own sentence is going to have to get through this. But I'm going to give you some understanding that I want you there. Not not because you want to be there, but because it's a court order, right? So, that's the sense of the court. I'm going to continue on probation with the addition that you will complete the share house program and all aftercare. I also have not seen the essay to the two state troopers, Gilmer and Harding. I know both of those troopers. I want your letter of apology to them to be sent to them at the state police post, post 12 on Bureau Road, right in Michigan. To make sure you get letters there. And this isn't, hey, I forgive you for what you did to me at the side of the road. This is, officers, I'm sorry for being an idiot at the side of the road and making your jobs harder than they needed to be. Understand?
Yes, sir.
I think at this time that you had this reflection in Shar House, I think that your clarity of mind and remembrance of how that incident happened would probably be a little more focused, all right?
Yes, sir.
I need that letter, I want those letters to go to the state policeman, Troopers Gilmer, Trooper Hardin, and make sure you get a copy of the probation department so that I will see them. Also want, when you're in, I want an essay sent back to the probation agent, what you learned while you're in share house. Alcohol can inhibit your ability from doing the things that you're capable of doing. And you got a lot of gifts, and you got to use them. And alcohol just puts a roadblock in the way with you. That's what I'm saying. All right.
Yes, sir.
So the essay is what you learned when you're in share house about how alcohol inhibits your ability from going forward and being a successful person you can be.
Yes, sir.
All right. All other terms and conditions of probation shall remain in full force and effect. You complete that residential treatment and I'll follow patient treatment. All right. If you're to sit, and I want those letters out within a week to the troopers. And then once you leave Charles, you can then write the letter about what you learned while you're in there and how your life can be far more focused and successful without alcohol and drugs. All right?
Yes, sir.
You got my sympathies as your grandmother dying and alcohol didn't make it better.
Sorry.
There you go. All right. If you're satisfied with the sentence, you found that case for legal appeal. If you wish to do so, you must do so within 42 days. If you don't have the money to hire a lawyer, one year, 24, and pay for the county expense. Any questions?
No, Your Honor.
Good luck.
Thank you.
Your Honor.
Thank you, Judge.
Mr.